So drugs in the workplace is an ongoing issue for the restaurant industry, and it's extremely difficult to deal with. On the one hand, in California, you can certainly, with reasonable notice, test people that are post-offer, pre-employment drug testing. So the offer goes out to employ someone, but before they actually start, it's contingent on them passing a drug screen. Now, many employers choose not to do this for labor pool reasons or what have you, the cost involved in going ahead and testing everybody that you're offering an employment to, especially where you have a lot of turnover in the restaurant industry. Conversely, random testing in California is not going to be allowed in the restaurant industry, other than in safety-sensitive positions, and we're not talking about knives in the kitchen, we're talking about nuclear reactors and things like that. You are not going to be allowed to do random testing. If you have people driving federal motor carrier safety regulation trucks over road, or they're working in a nuclear reactor or working with high explosive materials, something like that, you may be able to do random testing. But in the kitchen, in a restaurant, you're not going to be able to. So the question is, where's the happy medium between testing everybody that walks in the door that I want to employ and not being able to test anyone through random testing? And the area that we can go ahead and test people is what's called reasonable suspicion testing. So you develop a policy that goes ahead and alerts everybody that you're going to test if there's a reasonable suspicion that someone is under the influence of drugs in the workplace. Whether it's medical marijuana or some other illegal substance, you're allowed to test if you have a reasonable suspicion and if you've diminished the expectation of privacy that your employees have through a written policy. Then you want to go ahead and train your managers on what to look for. Now, they may all say, hey, I know what to look for, I've been around this industry enough. But generally, we like to develop a checklist that goes ahead and creates some objective criteria that your managers look for and check off. This way, later on, when you've actually terminated someone and they turn around and come after you with some sort of litigation or an administrative complaint, you have documentation saying that on this specific date, this is what I saw. Blurry eyes, slurred speech, the person was having accidents, that type of thing. That documentation is critically important in beating back a claim under a reasonable suspicion scenario. But that's the best avenue in the restaurant industry, in my opinion, to go ahead and go with, is creating a reasonable suspicion policy and practice within the workplace.